So, very good evening, all the participants. So, today is a session on case studies. So, we'll be taking up 4 case studies. But before taking up case studies, I will tell you some situations. And then you apply your mind on those situations. And please tell me what you think of in this particular situation. So, the first situation which is being described is the toll tax collected by contractor. So, toll tax collected by contractor on behalf of municipal corporation. So whether it is an operational debt or not, this is the question.
Toll tax collected by the
Contractor on behalf of municipal corporation. So I'll tell you the facts of the case. The facts of the case was the claim was based on an agreement whereby the corporation had appointed the company as a contractor. So you can say that this South Delhi Municipal Corporation, they have appointed the company as a contractor to collect toll tax from commercial vehicles. The corporation was not providing any goods or services to the company, and to that extent was not covered under the definition of operational debt under section 5 subsection 21 of the IBC. This was so as the amount recoverable as arrears of tax was quite different from tax arising under statute. Section 5 subsection 21 of IBC covered tax arising under the statute, which is not the same thing as any due, which only for the recovery mechanism are termed as an arrears of tax. The word recoverable from any person from whom such sum is due as an arrear of tax under this act introduces a deeming fiction that the dues can be recovered as an arrear of tax to take benefit of the machinery under the Delhi Municipal Corporation Act 1957. However, this did not make a contractual due, which was the case in the matter of a tax. The deeming fiction was restricted to this municipal tax only and could not be extended to cover another act. The operational debt claim was not covered as a debt in respect of payment of dues arising under any law for the timing in force. The claim of the petitioner here was South Delhi Municipal Corporation. The claim of the petitioner as of dues arising under any law for the timing in force, the claim of the petitioner as operational debt did not meet the criteria as set out in section 5 subsection 21 of the IBC. That is, the claim of the petitioner did not fall in either of the following: claim in respect of goods and services and debt in respect of dues arising under any law in force and payable to the government or any local authority. So this is the case of South Delhi Municipal Corporation, which had given a contract to a contractor to collect toll tax. So the question here is whether the corporation is rendering any services to the contractor. The answer is no. So it says the corporation was not providing any goods or services to the company, and to that extent, it is not covered under the definition of operational debt. So here, suppose this contractor does not pay the tax collected to the municipal corporation, then whether it can be deemed as arrears of tax, the answer is no. So we can see section 5 subsection 21 also.
बट वो तो जो कंपनी है that may be taking some commission from the corporation because they are rendering service to the corporation.
अब इसमें क्वेश्चन क्या है? एक्चुअली इसमें फैक्ट्स ऑफ द केस क्या है? फैक्ट्स ऑफ द केस है कि ये कंपनी ने जिसने टोल टैक्स कलेक्ट किया उसने साउथ दिल्ली म्युनिसिपल कॉर्पोरेशन को दिया नहीं. अब साउथ दिल्ली म्युनिसिपल कॉर्पोरेशन क्या एज ऑपरेशनल क्रेडिटर एप्लीकेशन फाइल कर सकता है? दिस इज द क्वेश्चन.
No, sir. It
So
cannot file because even it's not an operational debt.
yes,
It is
so
it is a due. It is a due. In fact, it is a due from.
so this is section 5 subsection 21. Let us see section 521 which was referred to in this. So it says operational debt. So operational debt means a claim in respect of the provision of goods or services. So the question here is whether South Delhi Municipal Corporation is rendering any services. The answer is no. Including employment or a debt in respect of payment of dues arising under any law for the timing in force and payable to the central government any state government or any local authority. So it says that it is not even covered under areas of tax. Because the word recoverable from any person from whom such sum is due, as an area of tax, it is a deeming fiction only. So this South Delhi Municipal Corporation, who has entered into a contract with a contractor to collect toll tax from commercial vehicles, and if that contractor does not pay the dues, so the question here is whether South Delhi Municipal Corporation can initiate an application under IBC under section 9. The answer is no. So this is the case South Delhi Municipal Corporation versus MEP Infrastructure Developers Limited 2022 NCLT Mumbai case. Then let us see another situation. The other situation is the toll tax collected by municipal corporation from company not operational. The respondent company, being the highest bidder, was appointed as a contractor under an agreement by the appellant municipal corporation. So this case is South Delhi Municipal Corporation versus MEP Infrastructure 2023 NCLAT judgment. So when this application of South Delhi Municipal Corporation was rejected, it went to NCLAT. Now, what are the findings of the NCLAT in this case? So it says the respondent company, being the highest bidder, was appointed as a contractor under an agreement by the appellant municipal corporation to collect toll charges from commercial vehicles entering Delhi at various toll points. Since outstanding dues remained, the corporation issued a demand notice to the company, and various litigations were initiated by both the parties. The corporation, as an operational debtor, filed a petition under section 9 of the IBC, seeking to initiate the CIRP in respect of the company. The adjudicating authority dismissed the petition, as we have already discussed, inter alia holding that the claim was based on an agreement whereby the corporation had appointed the company as a contractor to collect toll tax from commercial vehicles, and that the corporation was not providing any goods or services to the company, and to that extent was not covered under the definition of operational debt under section 5 subsection 21 of the code, and that contractual due could not be treated as tax. The toll tax which is collected, that cannot be treated as tax also, because if tax is due, then also it will qualify for the definition of operational debt. But here, whatever is the tax collected by the contractor, that will also not fall under the definition of tax.
सर इसमें छोटा सा क्वेश्चन है, स्मॉल क्वेश्चन। ये जो टेलीकॉम कंपनीज है, इसमें जो गवर्नमेंट स्पेक्ट्रम यूज करने का राइट देती है, एंड कल को यदि वो टेलीकॉम कंपनी उसका नहीं करती है, मतलब उसका पेमेंट नहीं करती है, तो वो भी फिर आपको लगता नहीं सेम लाइन पे ही होगा, एंड उसमें भी गवर्नमेंट का कोई राइट नहीं होगा ऑपरेशनल एज एन ऑपरेशनल क्रेडिटर?
पहले इसको को डिस्कस करते हैं, फिर उसके साथ अलाइन करते हैं। इसमें क्या बोलता है? ये बोलता है कि claim was based on an agreement whereby the corporation had appointed the company as a contractor to collect toll tax from commercial vehicles, and that the corporation was not providing any goods or services to the company, and to that extent was not covered under the definition of operational debt under section 5 subsection 21 of the code, and that contractual due could not be treated as tax, and that the claim of the corporation was not a claim in respect of goods and services as debt in respect of dues arising under any law. यहाँ पर बोल रहा है ना, dues arising under any law for the timing in force, ये इसकी बात जो कर रहा है, पेमेंट ऑफ ड्यूज, तो इसमें भी कहता कवर नहीं होगा ये, क्योंकि ये क्या है, ये तो लोकल अथॉरिटी तो है ही ना, साउथ दिल्ली म्युनिसिपल कॉर्पोरेशन। It also found that there were pre-existing ongoing disputes between the corporation and the company pending before the High Court, in which there were several interim orders currently operational, on an appeal made by the corporation against dismissal of the petition by the adjudicating authority, the appellate tribunal held that our operational debt was a claim in respect of provision of goods or services, and the claim had to bear some connection with the provision of goods or services without specifying who was the supplier or receiver. Thus, the supplier in case of services was the company, and the corporation fell in the definition of, and the receiver was the corporation. Therefore, the debt owed by the company to the corporation fell in the definition of operational debt as defined in section 521 of the code, and not the claim by the corporation against the company. Therefore, toll tax collected by the corporation from the contractor was not an operational debt, but toll tax collected by the contractor on behalf of the corporation was operational debt. The appellate tribunal did not interfere with the dismissal of section 9 petition by the adjudicating authority, which was filed by the corporation. So this was the case. So they can make a case study based on this, and then they can include some other questions. Now regarding your question. So basically, if the government is giving spectrum license, basically they are giving the right to use, because it is a natural resource. So they say the spectrum is a natural resource, and the government also has got the right to give licenses basically. So the government is giving the right to use the spectrum basically.
Yes, yes.
So that will be covered under operational debt. Here also, the contractor is an operational creditor, because the contractor is rendering services to the corporation. But the question here was that the corporation filed the claim as an operational creditor. So which claim was dismissed. So this was the facts of this case. Now, let us take another question, ki buyback scheme and assured refund. अच्छा, there is another case, a sum of money which is invested with an intent of requiring equity stake in a company or some other interest in some of the properties. So a person is investing a sum of money with an intent of requiring equity stake in a company, because some people invest in this, they invest in the projects of builders, and they say that you give us equity stake in the company or some other interest in some of the properties of the company. So whether it can be clubbed as financial debt, this is the question. Let us see the facts of this case. So what they say? When transaction does not fall under the definition of financial debt, an investment cannot be equated with a loan. So they say there is a difference between a loan and an investment. I hope I have started the recording, है ना? Recording start कर दी ना? कर दी मैं.
Yeah, recording.
हाँ, याद दिला दीजिए कीजिए मेरे को, कभी-कभी मैं भूल जाता हूँ. So here they said an investment cannot be equated with a loan. In the commercial world, equity financing and debt financing are altogether different modes of finance, which are distinct from each other. Equity financing carries no repayment obligation, while debt financing involves borrowing of money, which is often repayable along with interest or some other charges, as may be settled between the parties. Therefore, a sum of money invested with an intent of requiring equity stake in a company or some other interest in some of the properties of the company cannot be clubbed as a financial debt, or for that matter, a loan transaction. In the notices, the petitioner himself has claimed that the payment in question was made with intent to buy 25% equity stake in the respondent's company, on the basis of which it could be safely concluded that the money was not given as a loan. Therefore, it cannot be said to be a case of money having been borrowed by the corporate debtor from the petitioner, nor the transaction can be clubbed as a loan transaction. The admission made by the corporate debtor in the reply that the transaction was an investment is of no consequence. So there is no document available containing terms and conditions of the alleged loan transaction, on the basis of which it could be determined as to when the loan was repayable or whether an interest was to be payable or not, especially when it was admittedly an investment for acquiring an equity stake in the corporate debtor. Therefore, the said claim transaction does not fall within the four corners of the definition of financial debt in terms of section 5, subsection 8 of the IBC, as it has absolutely no connotation or effect of a commercial borrowing. Apart from that, the petition was miserably barred by time. No case was made out to admit the same in terms of section 7 of the IBC. So this was the case Sanjay Pagrani alias Raju Pagrani versus US Hospitality Private Limited, NCLT, Mumbai judgment. Just a minute. So in certain cases, what happens is that a person invests money with a builder and he says that, okay, you give me stake in the project or you give me some other properties belonging to you. So that is also not covered under financial debt. Now let us take third case. It is regarding this buyback scheme and assured refund. Because they may put these conditions in the form of a case study. So page 383, let me, and I'll give you the screenshot of the book from where I'm reading. Page 383, it says this buyback scheme and assured refund. So what it says, the corporate debtor, in this case, they launched a buyback scheme. And as per the buybacks, you will find the many buyback schemes in newspapers. That okay, you invest in this project and we are offering a buyback scheme. So the corporate debtor launched a buyback scheme, and as per the buyback scheme, the corporate debtor invited applications for booking space in the project upon payment of 50% of the basic sale consideration for a period of 24 months, against which they promised to pay assured return for 24 months equivalent to 1% of the amount invested, and after the expiry of 24 months, refund the total amount invested along with premium at 16% of the initial investment. So this is the scheme. So they may frame a case study like this, that XYZ Limited has launched and published in newspapers, leading newspapers, a buyback scheme, and the contents of the buyback scheme are as under. They are inviting applications for booking space in the project upon payment of 50% of the basic sale consideration for a period of 24 months, against which they promise to pay assured return for 24 months equivalent to 1% of the amount invested, and after the expiry of 24 months, refund the total amount invested along with premium at 16% of the initial investment. It failed to honor its commitment. The adjudicating authority, in an application under section 7 of the code, took note that the agreements between the parties contained default clause stating that 3 consecutive checks of assured return of 1% per month would be treated as default, or single check bounced, principal or bulk payment on account of reasons insufficient funds or payment stopped by drawer or signature mismatch would lead to the occurrence of default on the part of the corporate debtor. So these were the conditions as per the terms of agreement. Therefore, it was held that bouncing of the checks issued by the debtor on the reason, but the reason given was different. The reason given was account closed, and the non-payment of the amounts thereafter clearly evidenced the occurrence of default. So as the conditions provided for in section 7(5)(a) of the code were thereby satisfied, the petition was admitted. So this is the case Kusum Chadda Ahuja versus C&C Towers Limited, NCLT Chandigarh. So on buyback scheme also, they may put a question. Now let us take another example of agreement to develop residential complexes. So what is this case? Let us see this case also. The applicant entered into an MOU for the development of residential complex and made payment to the corporate debtor. Just a minute. इसकी तो जरूरत नहीं है. So in this case, the applicant entered into an MOU for the development of residential complex and made payment to the corporate debtor. Under the agreement, the corporate debtor was entrusted with the development, construction, and promotion of the said project, having understood the time frame given for the development and construction of the project. On failure to complete the project within the prescribed time, the applicant filed an application for initiation of CIRP contending that the payment made was covered by section 58F of the code. So there is what are the facts of the case? That the applicant has entered into an MOU for the development of residential complex. So he is basically a developer and made a payment to the corporate debtor. Under the agreement, the corporate debtor was entrusted with the development, construction, and promotion of the said project, having understood the time frame given for the development and construction of the project. On failure to complete the project within the prescribed time, the applicant filed an application for initiation of CIRP contending that the payment made was covered by section 58F of the code. The adjudicating authority, however, finding that there was no such term of assured return or any agreement which may amount to the repayment for the time value of money, held that the applicant was not covered within the definition of the term financial creditor as defined in section 5, subsection 7 of the code. It further observed that the applicant was not an allottee and would not be considered a financial creditor just because it had made an investment in a real estate project. The case is Jagbasira Infra Tech Private Limited versus Rawal Variety Construction Limited, NCLT Chandigarh judgment. Then this matter went to NCLT also, and it was affirmed in Jagbasira Infra Tech Private Limited versus Rawal Variety Construction Limited, NCLT New Delhi, holding that an amount invested in joint venture projects in a capacity as a promoter and investor would not fall within the ambit of the definition of financial debt. Let us take another situation. In this case, it is a section 9 application. So let me tell you the facts of this case. So this is a case of dispute between the operational creditor and the corporate debtor. So in a case before the Chandigarh bench, the respondent is a corporate debtor. He had received the demand notice on 13th of April 2017. But the reply dated 24th of April, that means after 10 days, was dispatched only on 26th of April 2017. That is after the expiry of 10 days period provided in subsection 2 of section 8 of the code. And therefore the respondent cannot be said to have validly raised the dispute as contemplated by the code, because here suppose the corporate debtor receives a demand notice, then he has to reply within a period of 10 days. But here in this case, they received the demand notice on 13th of April, but the reply dated 24th of April was dispatched only on 26th. That is after the expiry of period of 10 days. And therefore the respondent cannot be said to have validly raised the dispute as contemplated by the code. The tribunal, however, was of the prima facie view that if notice of the dispute is not received within a period of 10 days, section 9 of the code entitles the operational creditor to file the petition after the expiry of the said period. This is what is written in section 9. But the contention that reply received after the expiry of 10 days period cannot be considered at all is unacceptable, especially when the notice of dispute was available with operational creditor when the application under section 9 of the code was filed. So here the facts of the case was when the operational creditor filed the application, this notice of dispute was available with the operational creditor, although it was received after a period of 10 days. So the tribunal held that it was not a case in which it can be safely inferred that no notice of dispute was received by the operational creditor for entitling the petitioner to an order of admission under clause 1 of subsection 5 of section 9 of the code. Having said so, there is no alternative except to hold that the notice of dispute has been received by the operational creditor and therefore the petition deserves to be rejected. So the citation is ANC Knitcraft versus Foremost International Private Limited 2017 NCLT, Chandigarh. A corporate debtor who fails to notify the operational creditor of the existence of a dispute before the expiry of 10 days from receipt of the demand notice forgoes this right unless the corporate debtor is able to show definite proof of a dispute preceding the demand notice. Atul Roy versus Technofac Contracts Private Limited. They overruled Technofac Contracts Private Limited versus Yatri Vihar Hospitality. Although the corporate debtor had not replied within 10 days, it had replied shortly thereafter. Observing that the requirement of 10 days being directory in nature, the appellate tribunal held that the criteria of section 9 of the code for raising the dispute had been met. So these are some of the cases on which they may frame case studies. Now let us see some of the case studies which I have already circulated to you. So this I have already circulated to you. Now let us see. These are some of the questions. I hope you must have seen these questions because these questions are based on section 3, definition sections. Let us see this case study because it is based on the initial provisions. So there is a company XYZ Limited. It is having its corporate office at New Delhi and registered office in Noida. So if a company has got corporate office at New Delhi and registered office in Noida, where you will give this public notice, this क्या बोलते हैं, public announcement. Where will you publish the public announcement regarding initiation of this commencement of CIRP process? Suppose
It
you are
should
an
be at
IRP.
registered office, I think.
And regarding corporate office?
No, corporate office is there, but registered office has legal value, na? So as per registered office, you can go to NCLT or what court or whatever it is. I think so.
No, there is no question of thinking. You have to go as per the rules and regulations. So what? Let us see what regulations say on this. Regulation 6 talks of public announcement. So let me side by side open regulations also. So please open CIRP regulations also. And let us see what is there in that. ये regulations आ गए हमारे, एक मिनट.
Because in MCA website, you will find only registered office address. There is no corporate office.
नहीं वो ठीक है. But suppose you have got knowledge, ये public announcement. एक मिनट, मैं जरा ना इसको वो कर देता हूँ. Let me share. अच्छा अभी तो केस स्टडी भी नहीं शेयर हुई लगता है ना. ये केस स्टडी है. दिस इज द केस स्टडी. ठीक है. और एक मैं दूसरा भी शेयर करता हूं आपसे, ये रेगुलेशंस. तो रेगुलेशन देखते हैं. रेगुलेशन 6. व्हाट रेगुलेशन 6 says? रेगुलेशन 6 says दैट द पब्लिक अनाउंसमेंट कहां पर होनी है? रजिस्टर्ड ऑफिस एंड प्रिंसिपल ऑफिस इफ एनी ऑफ द कॉर्पोरेट डेटा. तो इट नॉट ओनली टॉक्स ऑफ रजिस्टर्ड ऑफिस. रजिस्टर्ड ऑफिस, principal office, any other location where in the opinion of the IRP the corporate debtor conducts material business operations. तो ये है, this is the provision.
That means registered office is mandatory.
मैंडेटरी और नॉट मैंडेटरी बात ही नहीं है. रेगुलेशन 6 पढ़िए ना. रेगुलेशन 6 क्या बोलता है? रेगुलेशन 6 बोलता है अभी तो बताया आपको, रजिस्टर्ड ऑफिस एंड प्रिंसिपल ऑफिस इफ एनी। तो अगर कॉर्पोरेट ऑफिस दिया है तो वहां पर भी करना है आपको, वो प्रिंसिपल ऑफिस ही मान लिया जाएगा ना एकदम से।
That's why, sir, principal office, if
बोथ
any.
बोथ प्लेसेस पे होगा ना सर, दोनों पे होगा।
हाँ बिल्कुल, हाँ। अब उसने केस स्टडी में दिया ना 2 ऑफिस आपको, तो दोनों पर करना है आपको।
और अगर 3 होते तो तीनों पे करते हैं हम।
3 10 होते 10 पर करते। सपोज
Okay.
देर आर 10 प्लांट्स विच आर लोकेटेड इन डिफरेंट सिटीज, देन यू विल डू एट 10 प्लेसेस।
Correct, correct.
And where this application will be filed? This company has taken loan from PNB, New Delhi. So where, in which NCLT you will file this application?
New Delhi bench.
Yes. So based on the registered office. Registered office में फाइल करनी है ना आपको?
Yes, yes, yes.
तो रजिस्टर्ड ऑफिस कहाँ पर है?
Delhi.
दिल्ली में कहाँ? नोएडा में?
नहीं, नोएडा में।
हाँ, तो यूपी में है।
तो
तो यूपी
हाँ,
का जो एनसीएलटी है वो इलाहाबाद में है।
इलाहाबाद।
एनसीएलटी इलाहाबाद में फाइल करनी होगी ये पिटिशन। So company has taken loan from PNB, New Delhi. Total outstanding loan of PNB is 95 lakhs, excluding interest of rupees 15 lakhs up to 30th of June 2021. So whether this application can be filed, because the outstanding is 95 lakhs only.
Trust can also be clubbed so that he can file.
Yes. So that
95 plus
includes
15.
not only the principal amount but interest also. ठीक है?
इंटरेस्ट एनी पेनल चार्जेस एवरीथिंग, व्हाट इज द टोटल आउटस्टैंडिंग?
हाँ बिल्कुल बिल्कुल बिल्कुल। तो ये आपका कौन से सेक्शन में लिखा हुआ है? सेक्शन 5 में लिखा है क्या? सेक्शन 5 सब सेक्शन 8 क्या बोलता है? फाइनेंशियल डेट मीन्स ए डेट अलॉन्ग विद इंटरेस्ट इफ एनी। So interest will also be included. The company defaulted in payment of debt to PNB and bank filed CIRP petition under section 7. On 7th of August, public announcement was made. So they have not indicated when this CIRP application was admitted. ठीक है? So in situation में insolvency commencement date कौन से लेंगे आप? What will be the insolvency commencement date? So you can take this date of public announcement as CIRP. उसमें कोई दिक्कत नहीं है, because public announcement is to be made immediately, maximum within 3 days. तो अगर नहीं है तो आपको कुछ प्रिज्यूम करना है, तो क्या प्रिज्यूम करोगे कि CIRP is on 7th of August, and we are presuming that say on the same day public announcement was made.
So
Actual,
there will be no cooling period like 3 days or 7 days.
ना 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 3-7 days तो होता ही नहीं ना, उसमें क्या, मैक्सिमम तो विदिन 3 days आपको पब्लिक अनाउंसमेंट करनी है।
Okay.
हाँ, ये लिखा है ना आपका, ये आपने रेगुलेशन पढ़ा होगा, ये रेगुलेशन में दिखा देता हूं आपको। ये रेगुलेशन है। रेगुलेशन में क्या बोलता है? An insolvency professional shall make a public announcement immediately on his appointment, and immediately means not later than 3 days from the date of his appointment. So XYZ Limited is in the business of generation of power from coal. So if XYZ Limited is in the business of generation of power from coal, so whether coal can be treated as critical input?
Yes.
And where are the provisions regarding this critical inputs?
14(2)(a).
Yes. So section 14 talks of this critical inputs. And what it says, if you go to section 14 में मैं आपको दिखा देता हूं यहीं पर ही। So this is section 14. And new share.
14(2)(a), sir.
हाँ, insolvency resolution. ये आ गया ना आपका 2A? It is there on screen या नहीं?
Yes, yes. The supply of essential goods and services.
हाँ. So where the IRP or RP as the case may be, consider the supply of goods or services critical to protect and preserve the value of the corporate data and manage the operations of such corporate data as a going concern. then the supply of such goods or services shall not be terminated, suspended, or interrupted during the period of moratorium, except where such corporate debtor has not paid dues arising from such supply during the moratorium period or in such circumstances. So here, since it is in the business of coal, just a minute. So it is in the business of generation of power from coal. And the coal supplier had total outstanding of 20 lakhs before CIRP. RP informed him that coal is a critical input and the company is ready to clear the current dues, but the dues before CIRP date shall have to be claimed through filing claim form. But the coal supplier says that I'm nothing doing, I want the total dues cleared. So despite this assurance, supplier discontinued the supply of coal. So now what option is available with the RP? We welcome Sunil Sethi ji.
Good evening, sir.
Good evening ji, good evening. हाँ जी, बताइए कि भाई उसके पास क्या ऑप्शन है। अब वो कहता है भाई मैं तो नहीं देता, जब तक मेरे पैसे नहीं दोगे मैं तो नहीं दूंगा गुड्स। आरपी बोल रहा है उसको भाई ऐसा है कि ड्यूज अप टू द इंसॉल्वेंसी कमेंसमेंट डेट यू कैन क्लेम थ्रू क्लेम फॉर्म, और करंट ड्यूज हम क्लियर कर देते हैं। वो बोलता है मुझे नहीं पता। इन्होंने बोला भाई ऐसा लिखा हुआ है आईबीसी में। बोला मैं क्या करूँ, आईबीसी में लिखा है तो क्या होगा
तो
उसके?
किसी को फोर्स तो नहीं कर सकते ना आप कि वो सप्लाई करे।
क्यों नहीं फोर्स कर
एज
सकते?
पर मतलब नहीं, कोई उसका एग्रीमेंट तो ऐसा होगा नहीं। यदि एग्रीमेंट है तो एक अलग बात है, बट एग्रीमेंट नहीं है तो वी कैन नॉट फोर्स, कंपनी कैन नॉट फोर्स दी सप्लायर।
नहीं नहीं देखिए ऐसा क्या लिखा, ऐसा है ना, वो हम अपना अजम्पशन कुछ नहीं। सेक्शन क्या बोलता है, सेक्शन 14(2) क्या बोलता है? सप्लाई ऑफ सच गुड्स और सर्विसेज शेल नॉट बी टर्मिनेटेड, सस्पेंडेड और इंटरप्टेड ड्यूरिंग द पीरियड ऑफ मॉरेटोरियम except where such corporate debtor has not paid dues arising from such supply during the moratorium period or in such circumstances. तो बेसिकली क्या है, करंट ड्यूज अगर देगा तो सप्लाई डिसकंटिन्यू नहीं कर सकता। कई बार होता है कि उस एरिया में एक ही सप्लायर है तो उसका यूनिट ही बंद हो जाएगा। तो देखो ऐसा है, एवरीबडी हैज टू अडेयर टू द प्रोविजंस ऑफ द कोड। जो कोड में लिखा है वो तो हर एक को अडेयर करना ही है ना, तो अदरवाइज तो मॉरेटोरियम का कोई मतलब ही नहीं है। मॉरेटोरियम में तो बात ही यही है। मॉरेटोरियम में तो ये भी लिखा है कि अगर एसेंशियल गुड्स एंड सर्विसेज है तो उसकी पेमेंट करो ना करो तो भी आपको सप्लाई करनी पड़ेगी। टेलीफोन कनेक्शन, आपका वाटर कनेक्शन, इलेक्ट्रिसिटी कनेक्शन नहीं काट सकते, चाहे आप पेमेंट करो चाहे ना करो। बट दे हैव ऑल्सो गिवन देम एश्योरेंस कि भाई दिट विल बी ट्रीटेड एज पार्ट ऑफ इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट। ठीक है ना? तो अगर जो भी कॉस्ट होगी इट विल बी ट्रीटेड एज पार्ट ऑफ द इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट। सो बिफोर पेमेंट टू एनी अदर क्रेडिटर दे विल बी पेड। इसी तरह से ये वाली जो सप्लाई है अगर इसका भी पेमेंट नहीं हो सकता तो उसमें क्या होगा, इट विल बी ट्रीटेड एज पार्ट ऑफ द इंसॉल्वेंसी रेजोल्यूशन प्रोसेस। तो इस केस में अगर वो नहीं मानता है एंड इज द ओनली सप्लायर, तो एडजुडिकेटिंग अथॉरिटी को अप्रोच करेगा आरपी और बोलेगा भाई सप्लाई शुरू कराओ, नहीं तो हमारी तो कंपनी बंद हो जाएगी।
हाँ, बट यदि उस एरिया में इफ देर इज ए सेकंड सप्लायर तो आई थिंक फर्स्ट सप्लायर जो अभी कर रहा है वो तो बंद कर सकता है ना।
दूसरा सप्लायर क्यों देगा? दूसरा भी नहीं देगा, इसके तो कुछ ड्यूज भी बाकी है, उसको तो ड्यूज भी नहीं है।
हाँ,
सर
बट सेकंड
सेक्शन
सप्लायर, हाँ
जो
ये
सर कह रहे हैं ना
हाँ
वैष्णव साहब,
हाँ
सेक्शन
हाँ
14(2)(a is very clear about it. Please read that.
हाँ, सेक्शन 42 में लिखा है ना।
14(2)(a पढ़िए जरा।
हाँ, अगर आप पढ़ेंगे ना तो बिल्कुल क्लैरिटी आ जाएगी उसमें।
आप पढ़िए जरा 14(2)(a अगर आपके सामने है।
हाँ हाँ, ये स्क्रीन पर नजर आ रहा होगा, पढ़िए एक बार जरा।
where the interim resolution professional or resolution professional, as the case may be, consider the supply of goods or services critical to protect and preserve the value of the corporate debtor and manage the operation of such corporate debtor as a going concern, then the supply of such goods or services shall not be terminated, suspended, or interrupted during the period of moratorium, except where such corporate debtor has not paid dues arising from such supply during the monitoring period in such circumstances.
तो क्लियर लिखा है, shall not be terminated as may be specified. तो ये
Terminated, suspended. No, he will go to a NCLT.
हाँ, ए के पास जाएगा कि भाई ये कराओ. चलिए आगे देखते हैं. अब इसके बाद
I
क्या
hope आपका डाउट क्लियर हो गया इनका.
ठीक है.
बेचुरी जी, डाउट क्लियर हो गया आपका?
हाँ हाँ, हो गया.
सो मिस्टर डी, देखो हमें जो प्रोविजंस ऑफ कोड है वैसा ही पढ़ना है. हमें तो इंटरप्रेट ही करना है ना कोड को. जो केस स्टडी बनाएगा वो भी तो यही बताएगा ना कि भाई आपने कोड को समझा कि नहीं समझा. नाउ दिस मिस्टर डी इज द अर्स्टवाइल डायरेक्टर. अर्स्टवाइल मतलब पुराना डायरेक्टर था, अभी नहीं है. ठीक है, पहले था डायरेक्टर, पास्ट डायरेक्टर, एक्स डायरेक्टर. He has given a loan of rupees 10 lakhs and filed the claim before RP. And he admitted the claim, but Mr. D was not given place in the COC. अब ये जो पास्ट डायरेक्टर था, इसने 10 लाख रुपए का लोन दे रखा है, इसने क्लेम सबमिट किया, क्लेम एडमिट भी हो गया. ठीक है, बट इसको सीओसी में जगह नहीं दी. अब ये कह रहा है कि भाई मुझे तो सीओसी में शामिल करो, मुझे तो कंपनी की नॉलेज है पूरी. तो क्या करना चाहिए? करना चाहिए या नहीं करना चाहिए सीओसी में?
Actually, he is not related party at present.
यस. हाँ हाँ. बिकॉज
Suppose-
सेक्शन 524 जो है, इट डज नॉट टॉक ऑफ पास्ट डायरेक्टर.
Past case, correct. sir,
पास्ट
correct.
डायरेक्टर, ही इज ए पास्ट डायरेक्टर, सो ही हैज टू बी गिवन प्लेस इन द सीओसी.
She was correct.
अच्छा, मिस्टर एक्स, वन ऑफ द क्रेडिटर हैविंग आउटस्टैंडिंग ऑफ रुपीज 15 लाख फाइल्ड क्लेम ऑन 25th November, बट द आरपी डिड नॉट एडमिट द क्लेम. एक और क्रेडिटर है, उसके 15 लाख ड्यू हैं. ही हैज फाइल्ड द क्लेम ऑन 25th November. ठीक है, but the RP did not admit the claim. So was the RP right in not admitting the claim?
Yeah, if it is in within 90th day, I think he has to admit.
He has to file.
Yeah, if RP has not admitted, he has to file an application before NCLT,
Yes.
particular bench.
Yes. So if you have understood these provisions, then answering the case study is very easy. So with which authority petition for CIRP can be filed, since the registered office is in Noida?
UP, NCLT,
NCLT,
Allahabad,
प्रयागराज,
UP.
इलाहाबाद. ठीक है. Is adjudicating authority right in accepting the CIRP application? तो यहाँ पर क्या था, डेट आपका 95 लाख है और इंटरेस्ट आपका 15 लाख है.
Yes.
हाँ, बिकॉज द टोटल फाइनेंशियल क्रेडिटर इज मोर देन 1 करोड़. सेक्शन 58 क्या बोलता है? डिफॉल्ट ऑफ लोन इंक्लूडिंग इंटरेस्ट इज इन एक्सेस ऑफ 1 करोड़. अगर एग्जैक्ट 1 करोड़ होता तो हो जाती क्या, या नहीं होती? अगर आपका मान लो एग्जैक्ट 1 करोड़ है ना, 1
Yes.
रुपया ज्यादा ना कम.
Minimum 1 crore, no, anyway.
हाँ.
If it is 1 crore, okay.
हाँ, ठीक है. Now supplier stopped the supply of coal. ठीक है, is it correct?
Not correct, actually.
हाँ, so 14(2)(a) we have already discussed. So it says no, after moratorium the supply of critical goods cannot be stopped. And who will identify these critical goods? कि भाई कोई गुड क्रिटिकल है या नहीं है? Who will identify this thing?
RP.
RP will identify. ठीक है. Provided current dues are cleared. Whether erstwhile director is a related party or not?
No.
The answer is no. ठीक है, जो पास्ट डायरेक्टर है, he is not a related party. So whether an erstwhile director can be a member of COC? The answer is yes. Was RP wrong in not giving the place in COC to Mr. D?
Yes.
Yes. So he should have been given a place in the COC. Was RP wrong in not accepting the claim of Mr. X? Mr. X का claim आया था 90 days के बाद में. So the answer is no. So the RP was not wrong. RP was correct by not accepting the claim of Mr. X, since it came after 90th day from the insolvency commencement date. Now the best option available with the creditor will be to approach the adjudicating authority, citing reasons for delayed filing. And if the adjudicating authority admits, then they can file the claim. Suppose adjudicating authority also rejects. Now this creditor went to NCLT and they also rejected the stance of the creditor that we don't accept the claim.
Appeal to
Then-
NCLAT.
Yeah, so he can go to NCLAT. And if NCLAT also declines, then
Supreme Court.
Supreme Court. Yes, he can go to Supreme Court. So
What
within
is
how
the
much
timeline for going to Supreme Court?
time?
In how many days he can go to Supreme Court?
I think 30 days. 30 days, I think.
Sir, Supreme Court is different. That is why I asked.
Maybe 45 days. 30 or 45.
No, that is where the criteria is ना, वो तो 30 भी देगा 45 भी लिखेगा, दोनों
हाँ, वो तो
लिखेगा,
दोनों दे देगा आपको.
और आपको टिक एक करना है, दो तो कर नहीं सकते आप.
वैसे इन्होंने पढ़ा नहीं सर अभी वो ना, ये क्या है अभी ये
अच्छा
पढ़े हैं.
सॉरी
नहीं कोई बात, ये 32A तक पढ़े हैं इन्होंने.
अच्छा
हाँ 32A तक ही पढ़ा है
मेरे को
इन्होंने.
लगा शायद आप रिवीजन कर रहे हैं इसलिए.
हाँ ना ये है, ये वैसे आपको 62 में लिखा है, सेक्शन 62. अभी ये 32A तक गए हैं.
ओके.
हाँ, so within how much time CIRP form 7 form is required to be filed? CIRP 7 मैंने आपको दिखाया था. I had showed you that form in regulations. तो
30 days.
CIRP 7 जो है ये कब फाइल करना है आपको? मैं आपको रेगुलेशन में फॉर्म दिखा देता हूँ. ये टाइमलाइंस के बाद था ना फॉर्म. ये
Every 30
टाइमलाइंस
days.
ये 40 भी है. तो CIRP 7
File
आपको कब
within
फाइल
3
करना है?
days of the set date where any activity stated in a column to table not complete specified in terms of the
One day in the future, Donald Trump
within
has
3
a bunch
days of the set date and continue to file
knows that
CRP 7
the
every
devil is
30
waiting
days.
for it. I don't know what.
So actually, this form CIRP is to be filed within where an activity which is stated in column 2 is not complete by the date specified therein. Suppose public announcement is to be made immediately, but not maximum within 3 days. ठीक है ना? Not later than 3 days. Suppose that is not done within the specified time. So then every 30 days after every month you have to file this form CIRP 7 within 3 days of the said date and continue to file form CIRP 7 every 30 days until the said activity remains incomplete. अच्छा, ये वाला केस स्टडी देख लेते हैं. ये केस स्टडी नजर आ रहा है आपको?
एक छोटा सा क्वेश्चन कैन आई आस्क.
यस प्लीज सर, प्लीज.
इंसॉल्वेंसी स्टार्ट हुई 1st of January, so it has to be completed in how many days?
Of January 180 days.
180 days. Okay, so now you got an extension of 90 days. You applied and got an extension of 90 days. This is as per the law.
Yes.
Now this CIRP form 7, will it be filed after 180 days or 270 days? अभी सर आपको CIRP form 7 की बात कर रहे थे. It has to be filed on 100 after 180 days or 270 days because you got an extension of 90 days. जो अभी सर दिखा रहे थे आपको कॉलम, उसका नंबर 5 जो है उस टेबल में, वो देखिए.
Yeah.
That says CIRP is not completed by T plus 180 days. So whether you got an extension or no, that does not have any relevance for filing this form CIRP 7.
Right. Now let us take this case study which is based on section 29A and section 5 subsection 24. So this case study Special Metals Limited. It is an Indian company, and you can note down the important aspects of this case study so that you can answer it quickly. So Special Metals Limited, it is an Indian company. They submitted a resolution plan for Sky Steels Limited. So who is the resolution applicant here?
Special metals.
Special Metals. So you have to see the ineligibility or eligibility of Special Metals. And who is the corporate debtor here? The CD is Sky Steels Limited. On 1st July 2020, whose corporate insolvency resolution process commenced on 1st April 2020. It relied upon super gross. So the Special Metals Limited, who is the resolution applicant, they are relying on super gross. Now please note, super gross is neither a limited company nor a private limited company. So it says it is one of the shareholder, one of its shareholder. So it could be an individual, it could be proprietorship firm, partnership, anything. Nothing is specified. But since the words limited or private limited are not written, so it means it is not a limited or private limited. One of its shareholder to comply with the eligibility requirement, because you can submit a resolution plan in conjunction with somebody else also. So you can join hands. So to meet the eligibility requirement, suppose the documents say that companies with net worth of below 1000 crores cannot apply. So if you do not have a net worth of 1000 crores, so you will join hands with somebody. So in this case, Special Metals have joined hands with Supergross, one of its shareholder, to comply with the eligibility requirement relating to its total net worth. Special Metals Limited was incorporated 7 days before submission of the EOI as a joint venture. So the Special Metals is a joint venture. So who are the partners? Climax Enterprises Limited 40%, Supergross 25%, Max International Limited 20%, and Hall Exports 25%. So two are the companies. Here Climax Enterprises is a company, Max International is a company, but regarding Supergross and Hall Exports, we are not clear. They may be proprietorship, partnership, or individuals. Okay. Now, so you can write the percentages also. This may be important for the purpose of calculating associate or holding subsidiary relationship. It was also found that the shares of Climax Enterprises Limited were wholly owned by Mr. Siva Reddy, either through himself or through his relatives. So who is the owner basically of Climax? These are wholly held by Siva Reddy, either through himself or through his relatives. The proposed resolution plan suggested merger of Sky Steels Limited with Special Metals Limited. Okay. So what they are suggesting, that they will merge this Sky Steel Limited, okay, with Special Metals Limited. Mr. Raju Reddy, father of Mr. Siva Reddy, is the CMD and majority shareholder of Sky Steels Limited. Okay. So this company, both companies will be merged, Sky Steels Limited and Special Metals Limited. And who is the CMD and majority shareholder? Mr. Raju Reddy. And Mr. Raju is the father of Mr. Siva Reddy. Okay. So further, as on the plan submission date, Mr. Raju Reddy was the promoter of Sky Steels Limited, whose account was classified as NPA for more than 1 year prior to its CIRP commencement date. Okay. So this Raju Reddy is the promoter of Sky Steels Limited, and its account was classified as NPA. Mr. Raju Reddy has also given a personal guarantee to SBI for loans advanced by it to Sky Steels Limited. SBI Limited has issued a notice dated 29th June to Mr. Raju Reddy for making payment under the personal guarantee, allowing him 60 days to pay. Now this is the shareholding. Shareholding in resolution applicant. Who is the resolution applicant? Special Metals. So in Special Metals, the percentage holding is Climax Enterprises, Supergross, Max International, and Hall Exports. And This Climax Enterprises is wholly owned by Shiva Reddy. Now, Climax Enterprises is dash. What is the relationship between Climax and Special Metals? Climax और Special Metals में क्या relationship? ये percentage holding है.
Associate 40% only.
Supergross, a shareholder of Special Metal Limited, is Supergross और Special Metals में क्या relationship?
Supergross holding 25% of special metals, but
हाँ, Supergross is holding कितना है इसमें?
25%.
हाँ, 25% है स्पेशल मेटल्स में. तो दोनों के बीच में क्या रिलेशनशिप है? सुपरग्रॉस और स्पेशल मेटल्स के बीच में
Related party.
रिलेशनशिप है या नहीं?
हाँ, related party which controls minimum 25%. Related party only, sir.
हाँ, तो अगर आप इसका सेक्शन 25 सब सेक्शन 24 सब सेक्शन जे देख लीजिए एक बारी.
Yeah, 20%
जे क्या
controls
बोलता है?
20%.
हाँ, तो 524
controls?
जे if you see what it says, ये बोलता है एनी पर्सन हु कंट्रोल्स मोर देन 20% ऑफ वोटिंग राइट्स इन द कॉर्पोरेट डेटा ऑन अकाउंट ऑफ ओनरशिप और ए वोटिंग एग्रीमेंट.
Voting agreement.
तो द वर्डिंग हियर इज एनी पर्सन, क्योंकि सुपरग्रॉस कोई कंपनी तो है नहीं, बट द वर्डिंग हियर इज एनी पर्सन. सो द क्वेश्चन हियर विल बी वेदर सुपरग्रॉस इज होल्डिंग मोर देन 20%. द आंसर इज यस. तो 524 जे में दे आर रिलेटेड पार्टीज. नेक्स्ट क्वेश्चन देखें, मैक्स इंटरनेशनल और स्पेशल मेटल्स में क्या रिलेशनशिप? मैक्स इंटरनेशनल और स्पेशल मेटल्स कोई रिलेशनशिप है या नहीं?
Just
ये आपके सामने
10% holder.
हाँ जी भाई, मैक्स और जो स्पेशल मेटल्स है वेदर दे आर रिलेटेड और नॉट, क्वेश्चन ये है.
Sir, one thing, sir, we have to see in the angle of sky steels, because CD is sky steel, but we have to establish whether the related party is between.
नहीं 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 नहीं, ऐसा नहीं है. अगर अब तो 29 भी तो देख रहे हैं ना, 29 में भी तो रिलेटेड पार्टी की बात कर रहा है वो.
अच्छा अच्छा, ओके ओके ओके.
29 में भी तो रिलेटेड पार्टी की बात करता है ना. तो अब हमारा क्वेश्चन क्या है? हमारा क्वेश्चन ये है कि वेदर मैक्स एंड स्पेशल मेटल्स आर रिलेटेड और नॉट. भाई आपके सामने है, एक मोर देन 2% वाली कंडीशन भी है ना, बट उसमें क्या डायरेक्टर होना चाहिए, है ना? डायरेक्टर तो है नहीं और 20% भी नहीं है, तो ये अनरिलेटेड पार्टी, ये रिलेटेड पार्टी नहीं है मैक्स इंटरनेशनल और स्पेशल मेटल्स लिमिटेड. क्योंकि हमें क्या है, देखो स्पेशल मेटल्स लिमिटेड क्या है, इज द रेजोल्यूशन एप्लीकेंट. तो रेजोल्यूशन एप्लीकेंट में भी तो रिलेटेड पार्टी का कॉन्सेप्ट आता है ना.
No, but the definition 24 is specifically says related party in relation to a corporate debtor only.
तो
We
हाँ,
cannot we cannot implicate special metals whether it is related or not. But maybe it will come under person acting in concert, jointly, person acting in concert. Like that it will come, sir. A person shall not be eligible to submit resolution plan if such person
तो ऐसा है ना, आई
or any other person acting.
अटेंशन तो एक मिनट, सेक्शन 29A, सेक्शन 29 में कनेक्टेड पर्सन में आ जाएगा ना.
कनेक्टेड पर्सन में आ जाएगा.
कनेक्टेड पर्सन में देखो क्या बोलता है, होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी और रिलेटेड पार्टी ऑफ ए पर्सन रेफर टू इन क्लॉज 1 and 2. A person who is the promoter or in the management or control of the resolution applicant. Any person who shall be the promoter. तो shall be the promoter में आ जाएगा कि नहीं आ जाएगा? क्योंकि ये चारों कंपनियां तो टोटल बना रही है ना. ये जो कंपनियां हैं यही तो प्रोमोटर हैं. स्पेशल मेटल्स के प्रोमोटर कौन है? यही कंपनियां प्रोमोटर हैं उसकी.
Yes, yes.
These
Yes.
4 are the companies ना.
Yeah, 4 are related parties to special metals.
Yes. हाँ. मतलब if you see from section 524 angle, it is not a related party, but it will be deemed to be a person who shall be the promoter or in the management or control of the business of the corporator during the implementation of the resolution plan.
Yes.
अब हॉल एक्सपोर्ट्स और स्पेशल मेटल्स में क्या है? पहले यहां पर जो है ना, दिस आंसर इज बेस्ड ऑन section 524. So as per section 524, they are not related parties. But if you see section 29AJ, 29AJ2, any person who shall be the promoter, तो shall be the promoter में कवर हो जाएगी. ऑल एक्सपोर्ट्स और स्पेशल मेटल्स में क्या रिलेशनशिप है? ऑल एक्सपोर्ट्स और स्पेशल मेटल्स
More than 20% है तो
हाँ,
automatic.
मोर देन 20% तो कवर हो जाएगी, रिलेटेड पार्टी बन जाएगी. अच्छा, मिस्टर शिवा रेड्डी जो है और स्पेशल मेटल्स में क्या कनेक्शन है? अब देखते हैं जरा शिवा रेड्डी और स्पेशल मेटल्स में क्या कनेक्शन है. ये देखिए, शिवा रेड्डी पहले तो देखते हैं कौन है. ठीक है, शिवा रेड्डी है, शेयर है इसके पास क्लाइमैक्स एंटरप्राइजेस के
40% share.
Completely held by Shiva Reddy.
हाँ हाँ हाँ. तो अब हम
Yeah,
क्या
he
देख रहे
is
हैं?
promoter of Climax.
हाँ, ही इज द promoter of Climax and he is the promoter of special metals also. He will be, ये जो है any person who shall be the promoter or in the management or control of the business. तो 29A J2 is attracted. भाई सेक्शन 29A भी पढ़ना है ना आपको साथ में. सेक्शन 29A J2 क्या बोलता है? एनी पर्सन, वो कनेक्टेड पर्सन में आ जाएगा. तो शिवा रेड्डी का कनेक्टेड पर्सन है या नहीं है स्पेशल मेटल्स का? ये क्वेश्चन
Management or control of the resolution applicant. Yes.
है ना. तो ये कनेक्टेड पर्सन होगा कि नहीं होगा? 29A J2, एनी पर्सन हु शैल बी द प्रोमोटर. अब ये जो शिवा रेड्डी है, ये क्वेश्चन है हमारा कि शिवा रेड्डी कनेक्टेड पर्सन है, नॉट कनेक्टेड पर्सन है, रिलेटेड पार्टी है,
He
एसोसिएटेड
is
क्या
the
है?
promoter or in the management or control of the resolution applicant.
हम्म.
Promoter. Anyway, he is a promoter no, sir. Anyway, 40% he is the complete owner of Climax.
हाँ,
Completely, Climax is holding 40%. He is indirectly promoter because these are anyway corporate bodies. He will be the promoter.
अब राजू रेड्डी का भी कनेक्शन देख लेते हैं. राजू रेड्डी क्या है? राजू रेड्डी और शिवा रेड्डी दोनों रिलेटेड है, फादर एंड सन है. इसको भी देख
Father and
लेते हैं.
son.
ठीक है. और राजू रेड्डी जो है, राजू रेड्डी क्या था? राजू रेड्डी वॉज द प्रोमोटर ऑफ स्काई स्टील्स लिमिटेड.
Skills.
ठीक है. अब राजू रेड्डी और जो शिवा रेड्डी है, ये फादर एंड सन है. ठीक है ना. राजू रेड्डी इज द फादर ऑफ शिवा रेड्डी. और इसका जो अकाउंट है स्काई स्टील्स का, इट इज एनपीए फॉर मोर देन 1 ईयर. तो 29A वाली कंडीशन क्या है? 29A कंडीशन क्या है? ए पर्सन शेल नॉट बी एलिजिबल टू सबमिट ए रेजोल्यूशन प्लान इफ सच पर्सन और एनी अदर पर्सन एक्टिंग जॉइंटली और इन कंसर्ट विद सच पर्सन at the time of submission has an account or an account of a corporate debtor under the management or control of such person or of whom such person is a promoter classified as NPA. So ये 29A भी आपका अट्रैक्ट हो जाएगा.
He is attracting. Yes.
So Climax Enterprises is wholly owned by Shiva Reddy and is associate of SPV Special Metals Limited. ये तो स्पेशल पर्पस व्हीकल बनाया ना टू एक्वायर दिस कंपनी.
Correct. Correct.
ठीक है ना. तो स्पेशल मेटल्स लिमिटेड बीइंग द रेजोल्यूशन एप्लीकेंट. राजू रेड्डी इज एलिजिबल बाय वर्च्यू ऑफ सेक्शन 29AC. ठीक है ना. उसका एनपीए अकाउंट है. तो अकॉर्डिंगली शिवा रेड्डी जो है ये कनेक्टेड पर्सन हो गया ऑफ रेजोल्यूशन एप्लीकेंट.
Yes.
अब ये जो मिस्टर राजू रेड्डी है, राजू रेड्डी और स्पेशल मेटल्स में क्या कनेक्शन है? शिवा रेड्डी का तो देख लिया. अब राजू रेड्डी और स्पेशल मेटल्स में क्या कनेक्शन?
Connected person is the promoter or management.
ही इज ऑल्सो ए कनेक्टेड पर्सन. तो कनेक्टेड पर्सन में क्या क्या आ रहा है? कनेक्टेड राजू, ये आ जाएगा ना, होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी और रिलेटेड पार्टी ऑफ ए पर्सन विच इज रेफर टू इन क्लॉज 1 and 2। तो 29 जे में कवर हो जाएगा। इन व्यू ऑफ द अबव फैक्ट्स वेदर स्पेशल मेटल्स लिमिटेड ये एलिजिबल है या नहीं है टू बिकम ए रेजोल्यूशन एप्लीकेंट फॉर स्काई स्टील्स लिमिटेड?
Not eligible, sir.
It is not eligible. So it can, but whether it can become eligible?
Yeah,
हो
if
सकती है
it
क्या?
clear.
29C says, क्या बोलता है 29C?
को एनपीए के बाहर आना पड़ेगा।
हाँ, एनपीए से बाहर आना पड़ेगा। बोलता है provided that the person shall be eligible to submit a resolution plan if such person makes payment of all overdue amounts with interest thereon and charges relating to non-performing asset accounts before submission of resolution plan. अच्छा, अब ये देख लेते हैं केस स्टडी। ये क्या केस? ये देखते हैं, ये पार्टनरशिप फॉर्म है।
Sir, how many case studies will be given from CIRP, sir?
अरे केस स्टडी तो बहुत मिल जाएंगे आपको, आप चिंता मत करो।
No, 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 not in this, sir. In examination.
In examination, you will get 2 case studies based on CIRP and liquidation.
Oh, okay, okay.
So it may be exclusively on CIRP, it may be exclusively on liquidation, voluntary liquidation भी आ सकता है, fast track भी आ सकता है. So 40 marks are reserved for case studies on CIRP and liquidation.
Acha, they will ask only one question, one case study.
No, there are 2 case studies. So these case studies can be based on CIRP and liquidation. So CIRP and liquidation, they merge together. And CIRP, as you know, it includes fast track also. ठीक है ना? PPIRP they have considered separately. So it will include voluntary liquidation, liquidation also. So there are 4 processes, basically CIRP process, then this fast track process, liquidation process, and voluntary liquidation process. Out of these 4 processes, they can set up case studies covering 40 marks. ये वाली केस स्टडी देख लेते हैं एक बारी। Jamin Educomp Limited is engaged in providing coaching to CA students in NCR across various locations and availed loan facility of 500 crore from a consortium of banks as per details below. PNB 100 crore, SBI 200 crore, Canara Bank 200 crores. So this loan is secured against various properties and assets owned by Jamin Educomp Limited. So in this case, first of all, let us see the provisions regarding section 21(6)(a). So what 21(6)(a) says? Section 21(6)(a), if you see.
21(6), sir.
नहीं है?
Consortium finance.
हाँ, 21(6). तो 21(6) में आपको एक बार दिखा देता हूँ। Let me show you 21(6) also. तो उसके साथ थोड़ा सा एक आधा और क्वेश्चन उसमें ऐड कर देते हैं। ये regulations
Where the terms of the 21(6), where the terms of the financial debt extended as a part of consortium arrangement or syndicated facility provide for a single trustee or agent to act for all financial creditors. Each financial creditor may authorize the trustee or agent to act on his behalf in the committee of creditors to the extent of his voting share. Represent himself in the committee of creditors to the extent of his voting share. Appoint an insolvency professional other than the resolution professional at his own cost to represent himself in the committee of creditors to the extent of his voting share. Exercise his voting share, right to vote to the extent of his voting share with one or more financial creditors jointly, severally.
So I think now it is visible on your screen 21(6) है ना? नजर आ रही ना आपको स्क्रीन पर?
नहीं आ रही सर, नहीं
आ रही? एक मिनट,
आई थिंक स्लाइड नीचे हो गई।
न्यू शेयर करके ये हो गया, अब आ गई, आ जाएगी, थोड़ा एक आध सेकंड लगता है इसमें आने में।
हाँ जी, आ रही है सर।
आ रही है 21(6). अब 21(6) पे हमारा क्वेश्चन क्या है? 21(6) क्या बोलता है? टर्म्स ऑफ द फाइनेंशियल डेट। अब मान लो ये दिस इज ए कंसोर्टियम डेट, ठीक है ना? इसमें 3 बैंकर्स हैं बेसिकली, So now, where the terms of the financial debt extended as part of a consortium arrangement or syndicate facility provide for a single trustee or agent to act for all financial creditors. अब ये जो कंसोर्टियम अरेंजमेंट था, इसमें ये कहा कि भाई सिंगल ट्रस्टी या एजेंट है, ठीक है। सपोज दे हैव मेड, इसमें कौन कौन से बैंक्स थे हमारे पास?
पंजाब नेशनल बैंक, एसबीआई, कैनरा।
हाँ, सपोज दे हैव मेड दिस पंजाब नेशनल बैंक एज ट्रस्टी। पंजाब नेशनल बैंक को सपोज उन्होंने कहा कि भाई पंजाब नेशनल बैंक विल एक्ट एज ट्रस्टी, ठीक है, टू एक्ट फॉर ऑल फाइनेंशियल क्रेडिटर्स। तो अब क्या होगा? अब जो ईच फाइनेंशियल क्रेडिटर, पहले तो ये देखिए कि इसमें कौन कौन से लोन किस किस ने दिया। एक तो पीएनबी ने दे रखा है, ठीक है, पीएनबी, एसबीआई और कैनरा, ठीक है, 3 बैंक्स हैं। अब यहां क्वेश्चन क्या है? यहां क्वेश्चन ये है कि आउट ऑफ दिस कंसोर्टियम व्हाट दे हैव डन इज दे हैव provision for a single trustee and they say that PNB will be the trustee or agent to act for all financial creditor. So each financial creditor may authorize the trustee or agent to act on his behalf in the committee of creditors to the extent of his voting share. So the first question, whether the trustee has to be from these banks or they can appoint somebody else also.
They can appoint.
They can appoint other trustee also.
Okay, so let us say they have appointed Mr. Sohan Lal as trustee. Okay. So now my question is, this PNB, SBI and Canara Bank, they have given loan under consortium arrangement and they have appointed Sohan Lal as single trustee or agent. So now all these 3 banks, whether they have to give the voting instructions to Sohan Lal only or they can appoint their own trustee or agent. But let us see the wording before answering this question. It says each financial creditor may authorize the
The screen is
trustee
not,
or
sorry,
agent.
screen is not visible. The other screen.
नहीं, ये वाली स्क्रीन तो विजिबल है ना?
हाँ जी, ये वाली है।
21.6 वाली ना?
यस सर।
हाँ, तो कोई बात नहीं, दूसरी में कुछ है भी नहीं। दूसरी में क्या है? दूसरी को
ठीक है।
छोड़ दीजिए, दोनों स्क्रीन इकट्ठी नजर नहीं आएंगी ना एक्चुअली। अब उसमें क्या है भाई, देखो पीएनबी, एसबीआई और कैनरा बैंक है, उन्होंने सिंगल सोहन लाल को ट्रस्टी अपॉइंट कर दिया, ठीक है। मेरा क्वेश्चन क्या है? मेरा क्वेश्चन ये है कि तीनों को क्या सोहन लाल को बताना है या कोई अलग भी अपॉइंट कर सकते हैं?
They can appoint other person also.
नो,
But insolvency professional only.
इंसॉल्वेंसी प्रोफेशनल छोड़ दो, उसकी बात दूसरी आ गई। माय क्वेश्चन इज ईच फाइनेंशियल, व्हाट द प्रोविजन सेज, 21.6 सेज ईच फाइनेंशियल क्रेडिटर may authorize the trustee or agent to act on his behalf in the committee of creditors to the extent of his voting share. So they will tell Sohan Lal or whosoever is the single trustee or agent to act on his behalf in a particular fashion. ठीक है, they cannot appoint any other trustee or agent. पहली बात, number 1. Second question, that is another question, whether they can appoint an insolvency professional. Yes, the answer is yes. So in addition to Sohan Lal, अब इस केस में क्या होगा भाई? एज पर कंसोर्टियम अरेंजमेंट दे हैव प्रोवाइडेड फॉर ए सिंगल ट्रस्टी और एजेंट। अब जो भी वोटिंग इंस्ट्रक्शंस देनी है, बिकॉज वोटिंग इंस्ट्रक्शंस में भी डिफरेंट, पीएनबी मे बी इन फेवर ऑफ ए रेजोल्यूशन, एसबीआई मे नॉट बी इन फेवर ऑफ ए रेजोल्यूशन, ठीक है ना, कैनरा बैंक मे और मे नॉट बी इन फेवर ऑफ द रेजोल्यूशन। तो दे मे लाइक टू वोट इन डिफरेंट फैशंस, दिस मेंबर्स ऑफ कंसोर्टियम। तो ये क्या करेंगे? अपनी वोटिंग इंस्ट्रक्शंस किसको देंगे? जो भी सिंगल ट्रस्टी या एजेंट है, पहली बात। सेकंड इज whether they can appoint an insolvency professional other than the RP. Yes, the answer is yes. But who will bear the cost? They will bear the cost to represent himself in the committee of creditors to the extent of his voting share.
They themselves can represent. PNB can itself represent. Canara Bank itself can represent.
हाँ,
As
वो
per
तो आ ही
B.
सकते हैं, वो तो आ ही सकते हैं नेचुरली, वो तो आ ही सकते हैं। बट ये जो सिंगल ट्रस्टी या एजेंट है, इसको भी भेज सकते हैं। मेरे कहने का मतलब ये है कि each of them will not be able to appoint their own trustees. ये ऑथराइज करेंगे ट्रस्टी या एजेंट को टू एक्ट ऑन हिज बिहाफ टू द एक्सटेंट ऑफ हिज वोटिंग शेयर, बट इफ दे वांट दे कैन अपॉइंट एन इंसॉल्वेंसी प्रोसीजर. सो दिस इज माय अंडरस्टैंडिंग. सुनील शेट्टी जी, आपका क्या व्यू है?
बिल्कुल ठीक है सर आपका व्यू पॉइंट, कि अगर तो इन्होंने ट्रस्टी करना है तो देन इट विल बी कॉमन.
हाँ बिल्कुल. हाँ जी.
और अदरवाइज ये अलग अलग अपना रिप्रेजेंटेशन कर सकते हैं, चाहे तो खुद अपना बंदा भेज दें,
हाँ
चाहे कोई आईपी अपॉइंट कर लें.
बिल्कुल बिल्कुल बिल्कुल.
तो और वो ये भी कर सकते हैं कि जैसे आप 3 बैंक्स का एग्जांपल दे रहे हैं कि कैनरा बैंक और पीएनबी, ये तो इकट्ठा वोटिंग कर लें और एसबीआई जो है वो अपनी वोटिंग करे.
हाँ बिल्कुल बिल्कुल.
मतलब है कंसोर्टियम में, लेकिन उस कंसोर्टियम को कैसे भी तोड़ना चाहे तोड़
हाँ
सकते हैं.
बिल्कुल बिल्कुल
टू द एक्सटेंट ऑफ देयर वोटिंग शेयर दे
बिल्कुल.
आर ऑथराइज्ड टू डू इट.
सो देयर वाज अ डिफॉल्ट. अब ये वाली केस स्टडी नजर आ रही होगी आपको, है ना?
जी सर.
हाँ. तो अब इस केस में क्या हुआ कि डिफॉल्ट हो गया. नाउ सपोज ये दे वांट टू टेक एक्शन अंडर सरफेसी. तो सरफेसी में क्या है, इफ 60% ऑफ द मेंबर्स ऑफ द कंसोर्टियम हैव टू एग्री. ठीक है. अब इसमें क्या हुआ है कि पीएनबी का 100 करोड़ है, एसबीआई का 200 है और कैनरा बैंक का 200 है. सो आपका आउट ऑफ 500 एटलीस्ट 300 करोड़ वर्थ ऑफ डेट जो है ना, दे हैव टू एग्री इफ दे वांट टू इनिशिएट एक्शन अंडर सरफेसी. ठीक है. So 60% have to agree. So can PNB initiate proceedings under SARFAESI against Jameen Educom?
No.
Yes.
So PNB is contemplating action under SARFAESI. SBI has agreed to the proposal. देखो SBI भी लिखा है ना, तो PNB और SBI हो गए ना, 300 हो गया. कैनरा बैंक इज अगेंस्ट.
Ah, yes.
हाँ तो हो सकता. ठीक है ना. Since no agreement could be reached, उन्होंने सोचा चलो सरफेसी को छोड़ो. So PNB decided to file an application under Section 7 of the IBC. Can SBI and Canara Bank file a joint application along with PNB?
Yes, always joint application always can be filed along with financial creditors as Section 7.
हाँ तो joint application हो सकती है, कोई इशू नहीं इसमें. The application filed by PNB was admitted. Application file किया, admit हो गया. Mr. Daya, as suggested by PNB in his application, was appointed as IRP. ठीक है. Now, if Mr. Daya is appointed as IRP and he makes a public announcement, ठीक है, तो who will bear this cost of public announcement?
PNB, subsequently the committee will reimburse that amount.
हाँ जी सेठी साहब,
हाँ जी सर.
ये क्या बोल रहे हैं, बोलिए एक बार श्याम जी प्लीज.
What shall be the first action to be taken? Daya, after taking charge of IRP, making public announcement. Acha, taking custody and control, appointment of valuers, constituting COC. Acha, you have given section 17 B.
सेक्शन 17 ही आएगा ना सर आईआरपी की ड्यूटीज का.
So
Because the first thing he will have to do is taking custody and control of the assets.
Yeah, anyway, we have to think that already public announcement was given.
No, sir. He says what shall be the first action to be taken by Mr. Dhaya after taking charge of IR.
So as soon as you become aware of your appointment, first of all, what you do? You write a mail to the financial institutions, bankers, that I have been appointed as IRP, and henceforth no debit should be effected from the account except with my permission. The powers of the board stand suspended, and before taking any before effecting any debits, you will please keep me informed. So ये सबसे पहले एक्शन लेते. They go to the company and they will try to find out whether there are any cash balances available. So they will take charge of that. If there are any movable assets, they will take charge of those assets. ठीक है ना. तो public announcement usually takes time. So before public announcement, this custody and control is the usual step which they take. Now parents of various students, they had deposited, because it is a coaching institute, So parents of the various students, they had deposited fees for the tenure of 2 years. Okay. So there are 1500 such students. So do such students or their parents constitute a class of creditors? भाई स्टूडेंट ने फीस अपनी जमा करा रखी थी, ठीक है, और 1500 स्टूडेंट्स हैं, तो क्या ये क्लास ऑफ क्रेडिटर है या नहीं? So because these are operational creditors.
Yeah, yes, correct. They are
basically,
operation creditors.
So these are debts arising out of advance payment for supply of goods or services. So any payment, any debt which is arising out of advance payment for supply of goods or services is an operational debt. Some of the students studying are less than 18 years of age. So does it affect the right to claim money from the institute? Because they are minor, can they claim this money from the institute?
Yeah. Oh.
Acha, when Mr. Dahiya visited the various premises owned by Zameen Educom Limited, he found that Jishan and Company, a partnership firm, was also operating from the same premises. Suppose you are an IRP and you have been appointed as IRP of a particular company, but when you go to their premises, you find that a partnership firm is also operating from the same premises. So what action you will take as an IRP?
Operate from chain. Ask them to make alternative arrangements through their rightful occupation. Okay, anyway, you have only given answer.
No, you can give different answer also. And you have to give logic also. Because first of all, before taking any adverse view, you have to see the documents. So if they are in rightful occupation, suppose they are paying some rent, there is some lease agreement, so then they can continue also because some revenue is coming to the company. But suppose no revenue is coming, they are not paying any rent, they are just occupying the premises, then you can ask them to vacate also if they do not have any documents to prove their rightful occupation. Suppose they are not able to give any lease agreement or rent agreement, उनके पास कोई agreement नहीं है, they are not paying any rent. So बोलोगे आप भाई खाली करो यहाँ से आप. So in the first COC meeting constituted by Mr. Dahiya, the members of the COC passed a resolution for removal of Mr. Dahiya and recommended Mr. Lohia to be the RP. अब उन्होंने क्या किया, मिस्टर दहिया को रिमूव कर दिया और बोला मिस्टर ये. So what are the remedies available to Mr. Dahiya? जो पुराने वाला है, जो that who has been removed, उसके पास क्या alternative है? क्या डिसीजन एक्सेप्ट करना पड़ेगा या ही कैन गो टू एडजुडिकेटिंग अथॉरिटी, क्या हो भाई? सीओसी पहले तो ये बताइए कि कितना परसेंटेज चाहिए फॉर रिमूवल ऑफ मिस्टर दहिया. हाउ मच परसेंटेज ऑफ सीओसी इज रिक्वायर्ड?
66%.
66%. ठीक है. सो दे हैव द रिक्वायर्ड परसेंटेज ऑफ 66%. सो दे हैव पास्ड दैट रेजोल्यूशन. So the question is whether Mr. Dahiya can contest this decision, whether he can file an appeal या नहीं, क्या होगा?
He can file, but there is no use. Anyway, AA will pass order. See, the decision of the COC is final.
Yes. So see, he has to accept the decision of the COC and hand over the documents to incoming RP.
Yes.
Mr. Lohia, after taking charge, but let us twist this situation. In this situation, please note that there are some home buyers also. Okay? There are home buyers which constitute, say, 80% of the debt. Okay? And 20% is owned by the financial creditors. All the 20% they agree for removal of Mr. Dahiya. Okay? But now, out of this 80%, out of this 80%, 49% are 40%, say 40% are agreeing for removing Mr. Dahiya and 60% do not agree. Then whether Mr. Dahiya will be removed or not. देखो
Not
question.
removed, that is more than 50% who have casted their vote has to accept it.
Yeah.
The authorized representative has to follow that.
Yes, yes, yes. So more than, it has to be more than 50%, because here out of 80%, only 40% are in favor of removal of Mr. Dahiya. So this resolution will not be accepted, and it will be assumed as if अगर less than 50% होगा तो क्या होगा?
Then 50%.
So that means they are against this resolution. So it will be presumed that 80% are against this resolution. Individual voting count होगा ही नहीं इसमें. As per section 21(6)(a). 21(6)(a) क्या बोलता है कि more than 50% means 100%. तो या तो 0 होता है इसमें या 100 होता है. Individual counting नहीं होता in case of class of creditors.
Yeah, if it exceeds more than exceeds 50, that is 100.
Yes.
Yes.
But my question is, if it does not exceed 50, then what will happen? If it is
0.
50, then 0. Yes. So there is either 0 or 100. But on 12A, it is individual. Now, Mr. Lohia, after taking charge and issuing Form G, is preparing information memorandum. So while preparing information memorandum, there is a construction contractor, right? And his measurements, etc., are yet to take place. So the liability is not yet crystallized. So what treatment would be done to about such liabilities?
There are any unliquidated amounts payable. What treatment should be done about while preparing information memorandum? If there are any, Acha, this provision has come across, I think, somewhere. Unliquidated amounts payable. What treatment? Yeah, in fact, it includes contingent liabilities also, I think.
Actually, if there are any uncrystallized debts, so first thing is whether it is a claim or not. Whether these unliquidated amounts. So what are these unliquidated amounts? They are uncrystallized liabilities. So, like I'll give the example of a construction contractor.
Estimate should be made, correct.
So in this case, the best estimate of such liability has to be made by the RP.
Correct.
Mr. Lohia, in response to request for resolution plan, got 3 resolution plans matching the criteria fixed by the COC. How he will evaluate such plans?
He will put all the plans before COC. He will evaluate the plans in accordance with evaluation matrix. He will call the resolution applicants for a discussion. All the above.
Actually, if you see regulation 39(2), if you see what it says, and there is a difference here between the regulation and section. 39(2) क्या बोलता है? 39(2)
Yes, put before COC for its approval.
39(2) says the resolution professional shall submit to the committee all resolution plans which comply with the requirements of the code and regulations made along with details of the following, along with details of PUFE transactions. So it says he shall submit to the committee all resolution plans which comply with the provisions of the code.
Yes.
And then we see the section also. Let us see the section. In section also, there is a provision regarding, I think, section 25. Section 25 बोलता है शायद.
25 yes.
हाँ, section 25, section 25 subsection 2I क्या बोलता है? Present all resolution plans at meetings of the committee of creditors. So now there is a difference in the provisions of section and regulation. Section में क्या बोलता है? Present all resolution plans. ठीक है? और यहाँ क्या बोलता है? Regulation में? Regulation में बोलता है which comply with the requirements of the code and regulations.
Achha, all means only this complied only, I think.
नहीं सर, अगर आप इसके साथ साथ सेक्शन 30 सबसेक्शन 3 पढ़े.
तो सेक्शन 30 सबसेक्शन 3 क्या बोलता है वो भी पढ़ते हैं एक बारी. सेक्शन 30 सबसेक्शन 3 बोलता है आपका, the resolution professional shall present to the committee of creditors for its approval such a resolution plan which confirms the conditions referred to in subsection 2. So आपको क्या पढ़ना है इसमें? आपको एक तो सेक्शन पढ़ना है। पहले आपका आ गया सेक्शन 25, सेक्शन 25 2J था ना,
2I
2I, हाँ, तो
2I
सेक्शन
33
सेक्शन
39 2
25 2I, एक तो ये है सेक्शन आपका, ये 20।
ये क्या कहता है सर, प्रेजेंट ऑल रेजोल्यूशन प्लान्स एट द मीटिंग ऑफ COC। तो
हाँ
मतलब प्रेजेंट उसने करने हैं, लेकिन अप्रूवल के लिए
हाँ,
वो 32 33 कहेगा। वो ये तो बताएगा कि ये प्लान आए हैं।
33 and 39 2 are one and same, sir. 39 regulation and 33
ये सर
are
वही
one and
इसीलिए
same.
कह रहा हूँ ना, जो सबमिशन ऑफ रेजोल्यूशन प्लान, जो रेजोल्यूशन प्लान का जो सेक्शन है उसमें 33 में कहता है शैल प्रेजेंट टू द कमेटी ऑफ क्रेडिटर फॉर इट्स अप्रूवल सच रेजोल्यूशन। अप्रूवल के लिए मतलब उनको अप्रूव नहीं करवाएगा,
हाँ,
बताएगा कि ये प्लान आए थे, इनमें ये प्रॉब्लम है, जो भी है इस तरह जो अपने नोट्स देके उसको करेगा। तो ऐसा नहीं कि वो एलिमिनेट कर देगा।
तो आपको ये पढ़ना है।
RP will submit only the resolution plans which confirms.
दैट इज फॉर अप्रूवल। ही विल लाइक, जैसे अगर सपोज उसके पास 3 प्लान आए हैं, एक प्लान कोड को कंप्लाई नहीं कर रहा, तो बताएगा कि ये प्लान आया है लेकिन ये कोड को कंप्लाई नहीं कर रहा बिकॉज ऑफ सो एंड सो रीजन। सो अप्रूवल के लिए दीज 2 प्लान्स विल आर टू बी देयर टू बी कंसीडर्ड।
First evaluation will be done by RP only, no sir?
नो सर, evaluation will be done by COC.
Acha, evaluate resolution plans received. No, sir. The evaluation of which the resolution plans confirms the
तो सर
provisions.
आप 32 पढ़िए पहले, फिर 32 पढ़िए।
32. Yeah, 32 means the specific compliances are there. If
No,
a
sir.
particular-
What is the wording here? The RP shall examine each resolution plan received by him to confirm that each resolution plan, आगे वो जो compliances हैं वो करती है उसने।
Correct.
So he has just to examine. Examine करने के बाद then he will put forward for approval. अब 39 अगर आप पढ़ते हैं तो
No,
उसमें
sir. No. Once you complete the 32, then go to 33. See, once examination is done, and if he confirms that the plan is in compliance with 32, then he will put up before the committee of creditors for its approval.
सर फॉर अप्रूवल, लेकिन आप आगे ये जो 39(2) है वो पढ़िए।
Again, 39(2) is also same as 33.
And what does no 39(3) says?
The resolution professionals shall submit to the committee all the resolution plans
This is 2. We have already 3.
which comply with requirements.
No, sir, 3. 33. The committee shall evaluate the resolution plan received under sub-regulation 2 as per
evaluation matrix.
evaluation
2
matrix.
only again, sir. Sir, here.
So evaluation जो है that is being done by COC.
In my opinion, you don't require to put all the resolution plans. If the RP as per 33, if he satisfies, then he'll put before the COC. The same thing he is saying here also in 39(2).
Sir, you are right, but he will have to mention ना, अगर वो नहीं किसी का प्लान डाल रहा COC के सामने, तो कल को कोई कोर्ट में जाएगा तो वो मिनट्स में नहीं होगा, तो फिर कौन रिप्लाई करेगा उसका?
Let COC reject it now, and they can discuss this with resolution applicant also. भाई इसमें there is a provision for modification of the resolution plan also ना, हमने पढ़ा ना कि modify भी तो कर सकता है resolution plan. Resolution plan once submitted, whether it can be modified, the answer is yes.
Yeah, in 39(1)(1)(a).
एक और केस स्टडी देख लें फटाफट विड्रॉल वाली, या आप यही स्टॉप करें? I have already shared all these case studies with you, so you see these case studies, है ना, आप अपना पढ़ लीजिए, and then you can ask in the group also कि भाई कोई भी आपका एक आध दिन और कर लेंगे केस स्टडीज, या मेरे हिसाब से tomorrow we can start with liquidation and then we will again have a look at these case studies. In the meantime, you please go through all these case studies. देखो सारी case studies यहाँ करना तो मुश्किल हो जाता है ना. बहुत सारा मटेरियल हमने आपको दिया हुआ है. We have given you answers also, so you can discuss in the group. So best option will be that we can discuss in the group, and then I'll provide you a recording of the earlier sessions also. तो वहां पर भी आपको deliberation मिल जाएगा. So I think tomorrow onwards we can start with section 33. ठीक है ना. तो बहुत सारा मटेरियल आपको दिया हुआ है, इसीलिए दिया हुआ है कि पढ़ें इसको आप, है कि नहीं. तो आई थिंक वी कैन स्टॉप हियर. सो सेठी जी, योर कमेंट्स, फाइनल कमेंट्स.
नो सर, एब्सोल्युटली फाइन. बीच में डिस्कशन हो ही गया जी. आपके ऊपर क्या सर, आपसे ज्यादा बेटर कौन एक्सप्लेन कर सकता है.
मेरे को क्या लगता है कि सेठी साहब थोड़ा सा ना हमें क्या करना पड़ेगा कि वी हैव टू थिंक ऑफ सम मोर सिचुएशंस. आपने थोड़ा सा लेट ज्वाइन किया. मैंने आपके आने से पहले ना कुछ अलग से भी डिस्कस किया था इन लोगों के साथ.
जी, जी.
जैसे टोल टैक्स, आई वेंट थ्रू सम केसेस. ये एक तो टोल टैक्स वाला केस था. टोल टैक्स कलेक्टेड बाय द कॉन्ट्रैक्टर ऑन बिहाफ ऑफ म्युनिसिपल कॉर्पोरेशन. साउथ दिल्ली म्युनिसिपल कॉर्पोरेशन का केस था. इस तरह से कुछ बाईबैक स्कीम वाला था. एग्रीमेंट टू डेवलप रेजिडेंशियल कॉम्प्लेक्स एंड डिस्प्यूट वेयर रिप्लाई वाज रिसीव्ड आफ्टर द एक्सपायरी ऑफ 10 days. तो ये मैं ग्रुप में भी शेयर करूंगा, तो आपका भी इनपुट्स इस पर चाहिए होगा. तो आई
ठीक है
थिंक वी कैन स्टॉप द सेशन हियर, है ना. And tomorrow we can continue with liquidation. In the meantime, please go through these case studies whenever you find time, and you can discuss in the group. And once we complete this liquidation, then we'll again go back to the case studies. क्योंकि पहले देखो आप पढ़ लें, उसके बाद में स्टडीज को हम पढ़ें तो ज्यादा अच्छा है, नहीं.
एब्सोल्युटली सर, अदरवाइज समझ नहीं आती फिर.
हाँ, अदरवाइज इतनी जल्दी समझना फिर मुश्किल हो जाता ना. ये चीज हमने तो ये
Okay.
पिक्चर बार बार देख रखी है, इसलिए हमें समझ में आ जाती है. बस यही बात.
We should be comfortable in provisions, then only we can answer the case
Yes,
studies.
yes, that is true. Okay जी, good night,
Good night,
everyone.
sir.
Good night, all of you.
हाँ जी, okay.